your industry on board to give us a brief what's happening in the legal world. To give some credentials, there's probably no one better to talk to this audience than Stephen. He's, you know, even 20-something years ago when I was coming through the ranks, he was you know, working with a young Icon agency before they blew into a full-blown, you know, Holco. He was working with them and doing work with them. He's won, you know, countless courses and awards and also court cases, including a high court case where a client didn't want to pay an agency and he won that. So he's got many runs on the board today. He's going to give us a briefing of what we need to know, and he's going to run through, you know, the constant changes in the legal landscape, covering everything from copywriting to data law and privacy laws that is ever changing, consumer law, spam, trade marketing, laws for influencers, and pretty much everything in between. So without further ado, also guys, there'll be times for questions at the end, so hold on to the end with that. It'll be recorded and housed on our YouTube channel that can be found in our Education Hub, if not anywhere else. So I'll hand over to Stephen to take the reins and run him through his presentation. Stephen, over to you, my friend.
Well, thank you very much, Sam. Thank you, ladies and gentlemen, for taking the time to join me virtually for this webinar hosted by the Independent Media Agencies Association. And as my friends at the IMAA have indicated, today's presentation is Communications Law, Recent Developments in a Complex Legal Landscape. Today, I'm of course speaking from the Australian perspective, but many countries around the world have similar laws and regulations to the ones I will canvass today. I will take you on a tour of the laws, regulations, and codes that influence and restrict the claims and messages advertisers, your clients, can make in the Australian context. We will also examine recent legal court cases where advertisers, brands, and their agencies, and I'm not limiting this to media agencies, it's any type of agency these days, have got it wrong, and how these court decisions, together with some very significant law reform that's on the way, will impact the business of advertisers and their agencies for many years to come. My desire is that by the end of this webinar presentation, you will at least have an awareness of the laws, codes, and regulations that may apply to your campaigns in order to improve compliance and, if possible, generally elevate the standard of advertising in Australia. If one day you turn around and say a bald lawyer said something about this at a seminar once and you go ahead and investigate further, then for me that's a win out of today's seminar. In advance of presenting, I would just like to mention that there is quite a bit of information to get through on the slides, so I do need to move at a reasonably fair pace. And some of the slides contain a fair bit of content, and I apologise for that in advance. But it is my intention to provide you with some information that you can refer to after the webinar. At the end of this webinar, I will let you know we can just very simply download a copy of the slide deck that I'm presenting today. So you don't need to go crazy with a pen or type on keyboard and try to write everything down. So I hope you find that slide deck useful, and I can also provide it to Sam as well for behind the membership wall. Now, ladies and gentlemen, if you have any questions as we progress, as Sam indicated, I can take some questions at the end, and I will answer them for you if I can. And of course, if I'm unable to answer or get to your question today, feel free to reach out to me offline at any time, and I'm very happy to chat through with you. Many of you have my contact details already, but they are there on the screen, and I will publish them again at the end of the presentation. So, ladies and gentlemen, before I get underway in earnest, I would like to take you all back in time to Victorian London in the 1890s. What you have before you is an advertisement in the famous Carlyle and Carbolic Smokeball Company case. This is an ad, variously, that you see there that appeared in the London News in 1892. And what it was advertising was something called a carbolic smokeball. Here is a replica. I hope you can all see that because I can't see myself in the screen, but here's a replica. It was a rubber device that was inserted into one's nostril on either side and squeezed. And what that did was that it pressed a stream of carbolic acid into your nose. Now, carbolic acid has a number of purposes, but predominantly today it's used as a commercial paint stripper. As you can see from the advertisements there, it said it will positively cure you from all of those ailments that sit there on the big ad there, loss of voice, hay fever, whooping cough, croup. It's the approved cure for hay fever and influenza. And God forbid, it was also promoted for the nursery and for young children to use as well. Importantly, you can see the influencers of the day there providing testimonials for the product. And in those days, our influencers, unlike today, were members of the military, clergy, minor royalty, and politicians. But we still have our influencers of the day saying how good the product was. Importantly, there was a £100 reward put out there for anyone who actually caught influenza or one of these diseases when they used the carbolic smoke ball. And one Miss Louisa Carlisle used the carbolic smoke ball as directed, promptly caught influenza and asked for her money. Today, £100 is worth about, back then, £100, today's value equivalent is about £12,955. So a lot of money for somebody in those days. The Carbolic Smoke Ball Company refused to give her money, said we were only joking. She sued them, and in 1893, she won her case in the English Court of Appeal. Now, this case is an advertising case, and it is sensationally important in our law because it established the modern law of contract in advertising from an advertiser to the public at large. And it also established the modern law of modern consumer protection movement that we still see today with our consumer protection laws. For those of you in the therapeutic goods sector, you would also know that such a claim for a therapeutic good would never be allowed to be run today. And of course, such an ad today would be illegal. You would be forgiven, ladies and gentlemen, for thinking that such an ad could never happen today. But you would be wrong, and these kinds of ads are happening all the time. If I can share with you the Biocharge device, God knows how it worked or what it actually does, but celebrity chef Peter Evans, in the early days of the pandemic, claimed that this device could be used to cure the Wuhan coronavirus. It was also alleged to be proven to restore strength and stamina, coordination and mental clarity. It was also to recover you from injury and stress, accelerate muscle recovery and reduce stiffness in the joints. There was absolutely no basis whatsoever to make those claims and no therapeutic use demonstrated whatsoever. He was fined over $100,000 from the Therapeutic Goods Administration, and he was told to remove the device from sale. So there we have a modern day carbolic smoke ball. Indeed, Lorna Jane, on the 23rd of July 2020, again in the early days of the pandemic, Lorna Jane was ordered to pay $5 million in fines for making false and misleading claims to consumers about their activewear, which they said eliminated, stopped the spread of, and protected wearers against viruses, including COVID-19. And there you have it. It's the Rogues Gallery of 1890 through to 2020, and things are still happening today. So today's private briefing outline, ladies and gentlemen, I'm going to travel across a really broad spectrum of laws that will apply. I'll give you a highlights tour of the legal landscape as it applies today. Copyright, privacy and data, Australian consumer law. We'll just touch upon spam, trademarks, defamation, and law and influences is where we'll wrap up, which is a very interesting sort of small or mini area or microcosm of how all of the laws that you see from 1 to 7 can apply. So hopefully there'll be a bit of illumination by the end of it. So what's the helicopter view of the laws that we're talking about today? So a highlights tour of the legal landscape. As indicated, there is a coalition of laws, regulations and codes, industry self-regulation, mandatory codes, etc., that influence and restrict how products can be promoted to consumers. And that covers a vast myriad of laws. A lot of you would be familiar with quite a number of them, but you may not be familiar with all of them. The point to understand, of course, is that it's product and campaign orientated. So depending on the product and depending on the campaign, you just need to work out what laws, codes and regulations might apply. Not all of them will apply, but some of them certainly will. Understand that all the laws I'm about to talk about and all the examples I'm giving you apply not just to the brand. They apply to the agency or agencies involved in the creation of these campaigns, right down to the individual person inside the agency who was the account director in charge. Because historically we have legal cases against the individual account directors as well by the ACCC, and I'll talk more about that later. You need to consider each one and manage risk to demonstrate legal compliance. And demonstrating legal compliance as an agency is very, very important. It's also important to understand that the media channel you use will have different legal outcomes. If you're talking about TV, you're talking about mainstream press, billboards or social influencers, those different channels have a different application often of the law that will apply. The risks that we see and I regularly see is legal, commercial, reputational and regulatory and criminal that agencies and brands can face. And the landscape includes this sort of broad area of laws, and most of them we're going to touch on today: copyright, privacy and data, spam, telemarketing laws, consumer protection laws that are enforced by the ACCC and the Australian Securities and Investment Commission for financial services, trademarks, defamation, corporate regulation, regulator guidance requirements, gambling, gaming, lottery laws, and the innumerate number of industry codes of practice, whether they be voluntary or mandatory, depending on the industry sector or the product or service that your clients are selling. So that's the landscape. So I'll kick off now in copyright, because this is an area that is often overlooked inadvertently. In the realm of digital, social, it is becoming more and more important because of the use of content by agencies, by the brands and by influencers that they may engage, and everyone can be responsible for a copyright infringement in that chain, as I've mentioned. So copyright exists under the Copyright Act. A lot of you would have heard about copyright. Just a quick overview of the law before I give you some examples of that. So important to understand that copyright is an automatic right that comes into existence if something original is created by somebody and it's a person that creates it. You can't have copyright being created by an algorithm or an artificial intelligence platform or a monkey. There is a case where a monkey took a photo and there is no copyright in that photograph because a monkey can't have copyright because they're not a person. So it's original, it comes automatically. And it protects from unauthorized use of what I like to call content. We call it content. You can have a read there, but there's a whole lot of things that fall within what I call a combination of content. And importantly, in the advertising and media context for your clients, film and music or still images. So film can have 7 different copyrights in it. Each of them can be owned by somebody else or by the same person. And music can have up to 3 different copyrights. And we generally look at copyright lasting for the life of the author plus 70 years. So copyright lasts a long time. And what all copyright is a bundle of exclusive rights to do things with your work. And in our sort of realm or our world of communications, we talk about the right to communicate the work to the public, broadcast it, reproduce it, or place it on the internet. And there's a separate bundle of rights called moral rights that lives under the Copyright Act, and it's a separate set of rights that authors and creators enjoy to not have their work subject to false attribution, or to have their work attributed, or not to have it subject to some sort of derogatory treatment, unless they consent. And often in contracts with content creators, we ensure we get moral rights consents to do these things if we need to. There's a little bit of law reform on the way. I just quickly mention, I always like to mention what new laws are coming up. It hasn't come into law yet, but we'll be looking out for some law reform around orphan works. We often get a question, hey, we want to use this piece of content out there on the internet. We can't find the owner. Can we use it? Well, you can at the moment with a bit of managing a bit of risk. If you do it the right way, it's still infringement, but there will be an exception for orphan works if you do what you can to find the owner. And then there'll be a fair dealing defence for non-commercial use by lay people. And understand that every single day people are violating copyright laws all over the world when they post things online and in social. You'll see a lot of these key takeaways that I'll be giving you throughout this presentation. And my first key takeaway, light bulb, is please understand that everything you find online, including social, will likely be protected by copyright and moral rights. You can't use them without permission unless you have a defence to do so. And then generally the ones that we talk about are reporting the news, parody and satire, which we'll talk about in a moment, and criticism and review. So you must assume copyright exists. You must obtain ownership or a license if you want to use it from a person that actually owns it and has legal authority to give you that right to use. So that's copyright. Now, some interesting examples. So you'll find, ladies and gentlemen, that I'll just give an overview of the area of law, give you some key takeaways, and then I'll show you some cases where things have gone a little bit pear-shaped. The first one is the example of using an advertiser's logo and advertising copy without permission. And this is a case where Greenpeace used AGL's advertising get-up and logo to push their activist messages about them being the biggest climate polluter. Of course, AGL took exception to these large ads that went all over the country by Greenpeace, and they sued Greenpeace for copyright infringement. And they relied, and it's the very first time we've had a case on this, they relied on the parody and satire defence. And it was found by the court that they hadn't breached the copyright. Greenpeace could use AGL's logo precisely the way they did. And the court said that the mimicking of the AGL logo by Greenpeace was clearly satirical. The court said that the ridicule potent in the message is likely to be immediately perceived. Many would see these uses of the modified AGL logo as darkly humorous because the combined effect is ridiculous. So what does that mean? Well, this means that the implications for charities, not-for-profit organisations and activist organisations is that, yeah, they can use your clients' logos with immunity if this is what they do. And they won't have to face legal consequences generally. But it is not a licence for advertisers, your clients, to use for commercial purposes the brands of other organisations or other copyright, because doing so would not be fair. So if there's a commercial purpose, you can't rely on the parody and satire or criticism and review defences. Another one I'd like to share with you is the use of music without permission in advertising. And many of you will recognise the gentleman on the right-hand side there. It's Clive Palmer from the UAP, Twisted Sister there on the left. And in the 2019 federal election, Clive Palmer's UAP party published a song called Aussie's Not Gonna Cop It. And this song was broadcast extensively on TV, radio, and online. Now, Universal Music sued Clive Palmer, who authorised the ads, written and authorised by Clive Palmer as a political ad, it has to have at the end. And they said that his song Aussie's Not Gonna Cop It, infringed the music and the lyrical copyright in the Twisted Sister song, We're Not Going to Take It. He was found liable for copyright infringement, and he was fined $500,000 for what would be the commercial use of that song had Twisted Sister or Universal actually licensed him the music. But importantly, he was fined $1 million for what we call punishment or additional damages. And that is because he had contemptuous disregard for the copyright rights of the Twisted Sister song, and the ridicule that he in the very public ridicule he made of the case against him. $1 million was the largest fine at the time for additional damages. So what is the message that I'm giving you there? The message here is clear. In the advertising context, if you simply take and use a person's copyright with complete disregard to their copyright rights, for example, if you were told, no, you can't use it, or you just took it and used it, or you thought it was too expensive, so you try to create a lookalike work. And many, many times I've had clients that have said, hey, the licensing of this song is too expensive. So you go to a composing company and say, make us something like that. And you do that, expect to cop punishment damages significantly above the commercial value of the use. And that fine will apply both to the agency and the advertiser together, because the agency was authorising or part of the chain of supply in producing the ad. Another very simple, very quick one that I'll talk about is the use is a copyright case where the look and feel of a product was used of another brand without permission. And very simply in this case, we have State of Escape, which is for many years was selling a very popular brand of tote bag, distinctive looking tote bag. And then we have one Miss Schwartz that comes along and copies the tote bag and sells it online on her store. And she was sued under copyright for the exclusive right of artistic craftsmanship, saying, you've copied our artistic craftsmanship. Well, the court had a good look at it and said, well, we agree that a tote bag is a work of craftsmanship, but it's not a work of artistic craftsmanship. It just doesn't get to that level because, hey, it's a functional product and it's just not artistic enough. So they failed. And this case shows it's very, very difficult to protect the copying of look and feel of products under copyright law. And the only way your clients can protect themselves really in these circumstances is have some sort of patent or design registration, which is a different form of IP. But under copyright, very, very difficult. So that is copyright. And I just mentioned it because there have been many, many times when agencies and brands have come unstuck. And many years ago, I remember an agency scraped an image of a snake off some obscure website in some part of the world. And they used it in a banner ad for a bank, a major bank. And the banner ad went on online, and it was seen by the owner of the image randomly and caused all sorts of problems for the agency when they threatened to sue for copyright infringement. And of course, the agency ended up having to pay for it, not the brand. So look, this can happen anytime. Just quickly shifting gear to privacy and data. If there's one area that is got the most amount of law reform and the most amount of activity, legal activity going on at the moment, it is privacy and data. It is huge at the moment. Data-driven growth for marketers is where it's at. Very much media agencies need to be across what I'm about to speak about because of the work you do for your clients with data. So at the moment, we are in a realm and an environment of significant investigation reports and inquiries that look at the world of privacy and data. This is a busy slide. I'm just going to give you a quick highlights tour. But the critical report that kicked all this off was the Digital Platforms Inquiry that was commissioned, that was requested by the federal government, asked of the ACCC to report, and they released their report on the 26th of July. And it's a huge report. And this report effectively confirms that laws and regulations have not kept pace with technology and commercial practice. The report has a huge focus on consumer privacy and data, consent and transparency, and the outcome of this report and the investigations are going to have a huge impact on any business that has privacy and data as part of their business model. Since that was released, we have the Digital Platform Service Inquiry under this Digital Platforms Inquiry. That's been going since 2020. It ends in 2025. There have been a number of reports that have come out, and you can read there what they have covered thus far. Some of you might be familiar with them. The latest came out, the fourth report came out on the 31st of March 22. A third report came out last year on the 28th of October. We've got another report coming out in September and 22. We've got another one coming out in 24, and the final report will be due in March 25. Spinning out of this, we're going to see some significant law reform. Another inquiry that's running parallel as part of the Digital Platforms Inquiry was what we call the Digital Advertising Services Inquiry. And that is the one that really impacts agencies, media agencies, advertising agencies, in particular media agencies, because this is about the supply chain and the provision of digital advertising. It really ended up focusing on the anti-competitive and opaqueness of the big platforms, Facebook and say Google, and the anti-competitive conduct and the transparency issues that they create. And we all know how much your clients like to have everything transparent. The AdTech report came out on the 28th of September last year, and where there's a 5-year inquiry into markets going on at the moment. Law will come out of that as well. On top of all of this, the Privacy Act is also being reviewed. So we've got the ACCC leading a whole series of inquiries that impact privacy and data. On top of that, the Office of the Australian Information Commissioner, the Privacy Commissioner, is reviewing the Privacy Act to make sure it's up to date, because it's not. We don't have a report for that yet. And there's also a draft exposure bill has been released of a new online privacy bill, which will really target the big platforms. The key takeaway here is that there are going to be new laws and codes coming that have a big focus on transparency, consumer protection, and privacy and data. And the big essence and takeaway of all of this is choice, consent, and control being afforded to consumers. And I'll touch upon that in a moment a little bit further. So please remember those 3 C's, because that's really what all this is boiling down to. So this is what's coming, but right now we have existing laws that are in place, and the Privacy Act is already existing. But just as with the Australian consumer law, which we'll get to in a moment, there's been a resurgence in the use of existing law by these regulators because of what's come out of the Digital Platforms Inquiry. So they're not waiting for new law to come. They're getting underway and kicking goals with the existing laws. Arguably, they should have been doing that from the start, but they're catching up now. So what is personal information under the Privacy Act? Well, currently we have 13 Australian privacy principles. Some of you may know this. It generally applies to any business that deals in personal information. So if you handle personal information for your clients, you are covered by the Privacy Act. If you're an individual business and you have a turnover of more than 3 million, you're covered. Generally speaking, you need a privacy policy. You can't collect personal information unless it's necessary for a legitimate business purpose. And importantly, you need a separate collection statement that provides an upfront disclosure about what you're doing with personal information. That is one area that is still, since all these new laws came in 2014, 14 are still not being handled properly by many businesses. In terms of the advertising marketing context, interestingly, under the Privacy Act, it is not lawful to use personal information for direct marketing in any channel, except in special circumstances. Everyone does, and it's a curious way to come at it, but the special circumstances are where a person would reasonably expect that their personal information would be used for marketing communications. And you can achieve that expecting through a collection statement to disclose to people where it's at. And the other one is the key takeaway just on the privacy law is APP 7.3, where an individual would not reasonably expect to receive direct marketing. You can still send them direct marketing, even if they wouldn't expect it, provided you comply with those points A to B. But the critical element of that, which we're about to see in some of the cases, is that you can only do it if it's impracticable to obtain the consent in the first place. And arguably, with all the digital technology that we have and the devices and the ability to disclose, it is always practicable to obtain consent. You mightn't want to obtain consent, but it's practicable to do so. So this exception, to my mind, is really now relegated to the realm of direct mail. So that's where we're at with privacy. Now, under the Privacy Act, really we just have personal information as a form of data. There's a definition of what data is, and under our current law, personal information is really just information or opinion about someone who's identified. So Stephen von Muenster with my address and my email address that identifies me, that's personal information about me, or someone who's reasonably identifiable. And that contemplates the combining of some information about me with other information when taken together would identify me. And that is an area that has not been readily understood. And a lot of individuals, a lot of businesses think they have anonymous data when actually they don't. But all of that's about to change because our definition is going to start following the GDPR and the Californian definitions in the privacy reforms that are coming. Now, in the, sorry, for some reason that's gone the wrong way, in the GDPR and the California privacy laws, we start seeing indirect information, location data, identification numbers or identification indicators, genetic, mental, economic profiling, preferential profiling, all of that sort of indirect identification is captured as personal information. And so the key takeaway is that our definition is moving towards the GDPR and the California definitions. And if the definition of personal information travels into the realm of the indirect identification through any form of profiling, or any form of combination of data points with AI or artificial intelligence or data analytics technologies, if that can happen, then pretty much everything you think is anonymous is going to become personal information and then will be subject to the entire privacy regime that's coming. So that's something I just wanted to really draw to the attention of particularly our media agency friends, because you're going to have to comply just as much as your clients will when this comes in. So right now, as I've mentioned, we have prosecutions that are going after the big platforms and other players for privacy and data breaches. And that's why I said this area is so important. Under the current laws, forgetting the new laws that are coming, which will be extensive, but right now, after getting a GR from the Digital Platforms Inquiry, the Office of the Australian Information Commissioner has kicked off a case against Facebook back in 2020. We don't have a decision yet. But this is starting a trend of what we're seeing in the way in which these big platforms have been handling our data. And this one was simply the Digital Life app. It was simply an app that someone like me would download. I downloaded it. it then sucked in all of my friends' details without them knowing, like a honeypot, and sent it over to Facebook for monetization and political profiling purposes, even over Cambridge Analytica. This was part of the Cambridge Analytica scandal, and this was one of the triggers for the Digital Platforms Inquiry. Right now, we don't have a decision and we don't have a fine, but the OAIC is actually seeking a penalty for each individual act of disclosure, and the theoretical penalty is as high as $500 billion under the current law, and those fines are just going to increase with the new laws. So what is the key takeaway from the privacy ones? What's going wrong and what people aren't doing right is consent is not being obtained directly from the person involved, as happened here. The issue is about exercising choice and control about how their personal information was disclosed in this case. Here, one of the key things I want to mention is that whether you're an agency or an advertiser and you have a tech stack or a chain of supply of suppliers that help provide capability to enable you to deliver your end service to your clients to enhance their data-driven marketing, you need to have very strong contracts with everyone in that supply chain, including your own clients, to make sure that privacy is being protected, so that you're not liable or you have something to rely upon if things go wrong, like it's going wrong for Facebook here. Right now, we are seeing a current investigation by the OAIC into Bunnings and Kmart for facial recognition potential privacy breaches. So this is one that's just hit the press. We know about it. This article was posted just a couple of days ago in the ABC News. Question I have for you just to think about is that little small sign saying that happens as you walk into Kmart and mentioning it in some long privacy policy in a website, on Kmart's website or Bunnings' website, is that sufficient choice, consent and control to know that their personal information is being used for the purpose for which they're using it? I'll leave that with you to think about. This will be an interesting case. So I've spoken about privacy and data and the changes that are coming, and it's huge. And I've also spoken about how the current privacy law is being reanimated and aggressively pursued by the OAIC under the current Privacy Act. I'm now shifting gears into the Australian consumer law, because whilst this is an incredibly important law for advertising and comms generally, we're also seeing the consumer law being used to protect privacy and data under these laws as they currently exist. And it's a double whammy that's hitting anyone who uses data. So we'll talk about how all that's happening. It's very, very interesting. So under the current Competition and Consumer Act 2010, we have the Australian consumer law, and the Australian consumer law has two critical sections. Section 18, that prevents misleading or deceptive conduct, and there's Section 29, which is a series of specific misrepresentations like false testimonials, false associations, false product claims, things like that. Most of you would have heard of misleading or deceptive conduct under Section 18. It must be in trade or commerce by a person. A person can be a company or an individual, it doesn't matter. Interestingly, trade and commerce means that if Greenpeace says something about your company that you don't agree with, you can't sue them under this section, because Greenpeace doesn't do things in trade and commerce because they're an activist group. I've had that case arise before. So the ACCC enforces the ACL. And what you've got to understand with understanding if something is misleading or deceptive is what the impression is to the target audience. Not what you think it is, it's what the overall impression is to the target audience. One test is a reasonable, casual and attentive but not overly analytical viewer of the advertising material who's a member of the target audience. And it's not the target audience you intend to target as the agency for your client, it is the actual target audience that receives it, which is usually broader. It applies to any Marcoms channel, any product, any claim, and any message, and this law applies in infinite number of ways. There's the burger as advertised. If that's what you get, that's arguably misleading or deceptive conduct. The key takeaway from this section is that terms and conditions, elucidation, disclaimers cannot cure a misleading ad if the dominant impression is misleading to the consumer. You need to consider the media, remember I mentioned the media channel you use, and the impression conveyed by all the elements of that ad taken as a whole. And that can come down to who the talent is, or the influencer, the voice, images, music, text, film, all together. And that's what matters. You put yourself in the shoes of the consumer looking at the ad and ask yourself, well, what claim am I actually making to them? And what are they taking out from that claim? And if what they are receiving and what in their mind they're thinking is misleading, then you need to do something quickly because your ad will be misleading. Let's have a look at some examples where that's happened. And there's a myriad of them. So at the moment, I'm just giving you some advertising cases, and then we'll look at some privacy and data cases, all under the Australian Consumer Law. So Dodo, we all know Dodo, June 21, $2.5 million in penalties because they cherry-picked the fastest speeds their network could deliver at peak times and forgot to mention, by omission, the slower speeds, misleading by omission. Mosaic Brands, back in May 21, in the second part of the pandemic, selling face masks and hand sanitizers, 70% alcohol product claims, but when a sample was tested, it only claims had 17% alcohol. So $630,000 in penalties there. One would ask, why would they do something like that? But as I said, the rogues gallery continues from the 1890s. Uber. We've all heard that Uber is agreeing to penalties and has conceded that they were misleading or deceptive in their rideshare app when they gave a cancellation warning to consumers saying you may be charged a small fee since your driver is already on the way when you tried to cancel. The problem was their own terms and conditions said you wouldn't be charged. So by not obeying their own terms and conditions, and equally if you don't obey your own privacy policy, you will be found liable for misleading or deceptive conduct. $26 million for Uber. A really important one I want to share with you is the ACCC and Trivago case, because this is one that happened by way of an algorithm, and the penalty is huge, $44.7 million. Now, you can see Trivago, most people know that it was a platform enabling people to get the cheapest deals on hotels. The reason that was misleading was because on its website and on TV advertising, what it did was when someone put in a search, the consumer thought that the Amoma hotel or the apartments available through them was the cheapest because that's what they were told. Actually, that was the business or the site that paid Trivago the most amount of money to get the top ranking position. And that wasn't disclosed to consumers. So that was misleading. It was only when you clicked on more deals, that middle circle from 227, that you worked out that it's actually not the cheapest deal. And then the other 101 thing they got wrong was the strikeout pricing. The text in different colors, 420 and 299. Well, actually the 420 was the premium room and 299 was the basic room. And so they weren't comparing apples with apples. $44.7 million in fines. You can have a bit of a read of that one. Another one is that happens a lot, and there's been a number of cases over the years, search engine marketing. For those media agencies that are doing SEO, SEM optimization for their clients, remember you can be liable if you get this wrong as part of what you do for your clients. Don't get your SEM wrong. As EmploySure found out, when they bought search terms, EmploySure bought the search terms of Fair Work Commission, Fair Work Australia, Fair Work Ombudsman, which is a government body. They use the dynamic keyword insertion technology to bespoke the ad that came up there in the search in Google. And as you can see there, it has everything to do with Fair Work Australia, but there's absolutely no indication that it's employer, and you wouldn't know that until you click through and found that out. The ACCC took it, and the Ombudsman themselves took exception to a government department being used that way, and so they were sued. But Employer fought the case and said, hey, it's got ad there, and it's also got fairworkhelp.com.au, and if it was a government department, it would have .gov, not .com.au. Well, what do you guys think? Well, at first instance, they actually successfully defended the case against the ACCC. The ACCC appealed, and then the full federal court ruled unanimously in favour of the ACCC and said it was misleading or deceptive. Employer had to pay a penalty of $1 million, but now the penalty is being appealed, and the ACCC is looking for $5 million. The ACCC is on the warpath for this sort of thing at the moment. Key takeaway here is be very, very careful with the search terms that you buy, whether it be another party's brands or logo, trade names or government names or something like that. How it appears in that ad is what matters, not what happens when you click through, because you can't cure it by clicking through and going, oh, it's Employer. That won't work. So I mentioned to you that privacy is now being protected, not just by the privacy laws, but by this Australian consumer law. This is huge, this area. And what we are seeing is a pincer movement from the ACCC on the one hand and the OAIC on the other, coming at these big platforms and anyone else who is doing the wrong thing with consumer privacy and data. And I'll just quickly take you through a highlights tour of the next round of cases that are out there. Health Engine was a doctor appointment booking app. They were found liable for breaching the ACL, issued a $2.99 million fine because they were giving consumer data to insurance brokers. Yes, they told people in their privacy policy that's what they were doing, but it wasn't upfront and disclosed. No one saw it, so they were liable for misleading and deceptive conduct. On the 19th of October, we have a case against Google for false representations being made on their phone screen about the location data that is collected by Google Android phones from consumer users, from us who use these phones, because they didn't say that you need to turn it off in 2 places rather than just 1 place. The ACCC have successfully sued, and Google are liable for that, but we don't have a penalty at the moment. And what the ACCC is seeking is a very robust disclosure from Google on how location data is being used and their settings in the future. So Google is liable, but we don't have a penalty at the moment. Another case against Google was commenced in July 2020. This one is even more serious. This is like the Cambridge Analytica one. Using obfuscation and hazy terms and conditions, they have procured consent from many, many users of their personal information for commercial purposes, including targeted advertising. And they have been sued because they haven't properly explained how personal information is being used for these purposes. We wait to see the fine and the determination if indeed Google is found liable. It continues. ACCC in December 2020 have gone after Facebook. Facebook's in trouble with the OAIC for its This Is Your Digital Life app and Cambridge Analytica. They're now in trouble with the ACCC for their Onavo Protect virtual private network app, which they said to consumers was a private, protected and secret environment that you can confidently share personal information in. In reality, the app just simply collected, aggregated and used significant amounts of personal data for their commercial benefit, including identifying future acquisition targets. So They've been sued by the ACCC, and we await a judgment and a fine against Facebook for that. The fun for Facebook continues because in March of this year, the ACCC have sued them for the way in which they allow advertising in Facebook. So not just Facebook's apps that are doing the wrong thing and sucking data into a big black hole, but Facebook's ads, like you allowing people to advertise. And this is the case where prominent figures have like Dick Smith and David Koch and Mike Baird and Andrew Forrest have been fraudulently, their images and their personality have been fraudulently used to promote offshore financial scams. So they've been sued for allowing their platform to be used in that way. And that'll be a very interesting case. And when that comes out, we await the decision and we await the fine for Facebook there. Coincidentally, Andrew Forrest himself, because he was the target of one of these scam ads, he has brought a private criminal proceeding in Queensland against Facebook for the very same thing. And it's a different case, but it's because of the same set of circumstances. So, ladies and gentlemen, this is a huge area. Privacy and data, misleading or deceptive conduct under the Australian consumer law, and what all that means for privacy and data. Very simply, some key takeaways, which you can go back and read. But they're very much focused on this privacy and data space, as would be evident. You really need, your clients and agencies really need to consider what the terms and conditions of privacy policy say about the collection of personal information, and that it cannot be understood. Remember, I've mentioned it's about informed choice about how data is handled. If you say something in your privacy policy and you don't do what you say in your privacy policy or your terms and conditions, you could be liable, like Health Engine found out. If you don't obtain explicit informed consent, you can have liability under the Australian consumer law, even if that technically isn't liability under the Privacy Act. It is not good enough to simply bury consent in layers and folds of privacy policies, website apps, terms and conditions, because consumers are time poor and they're not going to see it. So what we look at is things like choice screens and opt-in measures that allow consumer control. And remember what I said, it is not just the business that will be liable, it is also the agency and individual employees in the agency that will also be liable under the ACL and the privacy laws. Choice, consent and control are the touch points. I ask that you run that mantra over anything that you do and ask if that's what you're delivering to the consumer at the end of the day. Shifting gears quickly to spam before we hit defamation and then influences and close off. I just mentioned spam briefly because spam has been around for a long time. Most people know about the Spam Act and the Do Not Call Register Act. The important point to understand is that if you have an exception under the privacy law for direct marketing, but the Spam Act applies, you can't rely on the privacy exception. The critical thing about the Spam Act is you need consent. You cannot send electronic messages to anybody unless you have their consent to do so. And then you have a clear sender identification and opt-out information and unsubscribe. Most people know that. Most businesses also know, and agencies know, that if there's a do not call register and your numbers on that, including mobile numbers, you can't contact people on the do not call register. Businesses are getting it wrong still. Woolworths fined $1 million for sending messages to consumers that have opted out. Optus fined $500,000 for doing the same thing. Smaller companies are breaching the do not call register. March 18, we've got $25,000 and $21,000 in fine for calling numbers on the do not call register. Just a couple of days ago, the penalty for Sportsbet came down for spamming people who had opted out messages regarding gambling, and they've had to pay a significant fine for that, as well as compensating people that gambled and lost during the time by reacting to those spam messages. So that just came down a couple of days ago against Sportsbet. So it's happening all the time. Can't quite understand why they get that wrong. There's some reform on the horizon with spam. I'll just quickly pass over it. But a lot of people got upset that Craig Kelly from the UAP last year was sending thousands and thousands and thousands of messages about how good he is for the UAP. Unfortunately, it wasn't unlawful under spam laws because, one, they weren't commercial messages, they were political, and also political parties are exempt. But we will see some changes under the spam laws coming because of that. I quickly mentioned trademarks to you because the agencies and their brands do get this wrong. Now, trademarks are different to copyright, because copyright is automatic, whereas trademarks under the Trademarks Act of 1995 is something that needs to be obtained, and it can take a long time to obtain them. But once you have a trademark in one of the 45 classes of goods and services, you have a monopoly right, or the owner has a monopoly right for the brand name, product name, or taglines and slogan to use that for that good or service that they have. And trademarks are what they are. You can see there's a trademark for Peps. It's the first trademark ever registered in Australia in 1906 under chemical substances for colds and bronchitis. There you go. It's probably an Australian version of a carbolic smoke ball. But that's what a trademark is, of course. And all of you as agencies have brand names, your clients have brands and trademarks. Now, you infringe a trademark if you use a mark that's identical or substantially identical or essentially similar as a mark, as a trademark, in respect of similar classes to a registered mark. So you've got to be very, very careful. And the key takeaway is you always got to check to make sure that there is no registered mark or some common law mark that has developed a reputation that is existing when you come out into the market with a new product name, a new brand name, or something like that, because it would infringe those marks. I just quickly mention a couple of classic fails because it happens. One of my favourite ones is organic marketing and Woolworths. Woolworths comes out with its honest to goodness paddock to plate food range using Margaret Fulton. This is back in 2011. They forgot to check whether there was a trademark, and we have honest to goodness or owned by organic marketing. The case settled, but obviously Woolworths weren't allowed to continue using honest to goodness as a trademark because of the competing trademark that was there. Another classic fail that I always like to share is the East Corp and Pacific brands. And very simply here, the Hottie brand has been owned by East Corp for many, many years for clothing and accessories. To celebrate the 100 years of Bonds, they came out with a series of apparel in big department stores, Boyfriend Hottie, Hipster Hottie, etc. And again, they were sued, the case settled, but we're assuming for quite a bit of money. So that can happen. Defamation. Now, the reason I mention defamation here for you today, ladies and gentlemen, is because it is raising in prominence in the realm of advertising, marketing, and communications. Defamation, very simply, is where one party publishes something, either orally or in writing, about another party that is untrue and harms their reputation. In the old days, it was slander and libel, but it's just called defamation today under the uniform defamation laws around Australia. So you can't do it, and it can happen in advertising. And I just quickly mentioned that there has been a bit of law reform. I always like to mention law reform. There's a new defence for public interest if the matter's in the public interest. There's a single publication rule because, of course, online you can have multiple publications of the defamatory material can go viral. And we talk about a single publication date being the first publication, and within that time, someone must bring a defamation action, and there must be serious harm to prevent frivolous and trivial cases coming along. Now, this doesn't often happen in advertising, I'll be honest with you. But the key takeaway is that it can be defamed in advertising if there's a publication. And advertisers need to be aware of that, and so do their agencies. I show an image there on the left-hand side because way back in 2007, Virgin put up a whole series of ads around Australia called Dump Your Pen Friend, Virgin to Virgin. The image of that young lady was taken from Flickr on a Creative Commons license, and she was out of the US from Texas. It just so happened, though, that her friends saw her image on the back of a taxi as they were driving from the airport into Sydney. And it caused a hell of a storm, but she didn't bring legal proceedings against Virgin in Australia. She actually decided to commence proceedings against Virgin in Texas. There's a long story behind that. The point I'm trying to make is you can defame individuals or people in advertising. Get talent releases and permissions to use people's images if you're going to feature them in a Dump Your Pen Friend style campaign. The most important thing, though, in defamation in recent times, particularly in digital and social, is the Dion Voller case. And most of you would have heard about the very serious imagery that came out of the youth detention. A Royal Commission was established. The problem, what happened here, is that the various newspaper outlets wrote a story about it, published it on their Facebook pages, and allowed their communities to comment and some of them in very, very defamatory ways about Mr. Voller, various injuries to his reputation. And he sued for defamation the owners of those Facebook pages, the newspaper publications. And the New South Wales Supreme Court and a Court of Appeal found in New South Wales that the publishers knew that those posts would engender such a reaction from their community. They had an obligation to moderate, and they didn't, and so they are deemed to be the publisher and they're liable for defamation. They went and took this to the High Court of Australia, and the High Court decided at the end of last year, yes, he was defamed. The Sydney Morning Herald, Sky News, The Australian were responsible as the publisher of the defamatory material. He was clear and free to continue his defamation action. Very quickly, the case settled, and the case has gone away and it was settled. But the point being that he was defamed by the comments, and the responsibility was with the newspapers or the publishers. Just recently, we've had a similar thing with John Barrialo, the former former Deputy Premier of New South Wales. He was defamed by Google because someone had published defamatory videos about him on YouTube. Google was told, and they failed to remove them. And so Google was just being found liable for defamation because they left it there and they didn't remove it. So there's another example. Google suffered the same fate, by the way, back in 2012 with image search terms with a fellow called Milorad Shradulka, because when you typed his name in, his image came up next to various gangsters in the Victorian underworld. And Google refused to move it then, and they were found liable back in 2012. So this is nothing new, but we're seeing it happen. The key takeaway is those that assist their clients with social media and they provide community management or they assist in moderation, you need to understand that if someone on a brand's page says something that is defamatory about someone who's identifiable, the person liable will be the brand. So moderation is super, super important. So I'm just going to wrap off now very quickly with the law and influences. So all the laws I've just spoken about apply in a very unique way to this new evolving communications channel, art form called influence, whatever you want to call it. It's becoming the center of many campaigns these days. And we've all had to grapple with how we engage with influencers and who's responsible for what they do. Now, the laws that apply in the influencer world, of course, the Australian Consumer Law up the top there is the most important one. Section 18 Section 29, I've already mentioned them. The two critical questions I'd like you to think about in the influencer realm is, one, influencers have to be accurate and truthful about their testimonials that they make about products and expressions of support. Because if that's not true, then the brand and the influencer and the agency are likely to be liable for misleading testimonials. But importantly is the disclosure of commercial associations and rewards for their expressions of support of a brand. On top of that, all the laws that I've already mentioned will apply to influencer marketing. I've listed them there on the left-hand side. We also have in the bottom middle square the Advertiser Code of Ethics, which I'll very briefly mention in a moment. But that's self-regulation and ad standards determinations under clause 2.7. And then we have a myriad of voluntary and mandatory codes of practice that apply. Financial services, the Therapeutic Goods Advertising Code, that's a huge one. A new code has just come out on the 1st of July, effectively banning the ability for influencers to give testimonials about therapeutic products. And that includes everything from sun cream to lip balm. You've got to be very, very careful. Alcohol, and then AIMCO I'll mention in a moment. So I'll just leave with you a slide that you can go and look in your own time, because I know I'm running short of time. A couple of slides. We have had successful cases under the ACL for a number of things: failure to moderate user-generated content on Facebook pages, modified customer reviews, fake testimonials, fake product reviews, but we don't have any cases involving influencers. But if you are involved in influencer marketing at the moment, understand that right now there is a warning that has just come out from the KCCC saying in 22 and 23, we are going after fake reviews in particular and social media influencers who do not disclose they are paid to promote products they pitch to consumers. That is now a target of the ACCC. It is not a matter of if, it is just a matter of when the next big case comes out, and we will see a brand, an advertiser, an influencer, and possibly an agency being sued by the ACCC for an influence campaign that has gone wrong. That is where this is heading. I'll leave with you the question of, when do we need to disclose a commercial association and a connection with a brand and an influencer? Well, my suggestion to you is you always disclose it. But I'm giving you a little bit of guidance there in the absence of any cases, what I feel from my experience you can do to understand when you need to disclose and how you need to disclose that. As I said, we haven't had a case, but very interestingly, back in 2012, we had a campaign at Kangaroo Island from the South Australian Tourism Commission. And you can see our friend Matt Moran there and Shannon Knoll talking about Kangaroo Island. But what we had was a whistleblower who went to Media Watch and said, did you know that we're being offered as a celebrity $750 plus GST to do one tweet, which is deliberately supposed to be appear organic and not endorsed. So that is a deliberate camouflage. Then and today, that would be misleading or deceptive. The ACCC didn't bring proceedings back in 2012, but a deputy commissioner said that that is something that is unlawful. Be very, very careful, otherwise you'll end up with a very messy end, she said. That's 2012, so this has been happening for some time. Most of you would know that under the Advertiser Code of Ethics, which is a self-regulatory code for self-regulation in Australia, I don't have time to go into that in depth, but 2.7 is the section that deals with distinguishing advertising as advertising. And that is the one that applies to disclosing influences and making sure that you clearly disclose that. And the key takeaways and the points there is what you need to ask yourself as to whether you need to comply with 2.7. If you don't comply with 2.7, then people can make complaints to ad standards. I'll quickly mention AIMCO as the Australian Influencer Marketing Council. They have an excellent code of ethics and a code of practice that gives a lot of guidance on how to stay safe when using influencers for both the influencer and the brand as well, and the agency. So I would recommend that you check out their code. 2 more slides. I just mentioned ad standards cases because this is self-regulation under 2.7. One case that was upheld where a consumer complained, and another case where it wasn't. In this case, Samsung Electronics, it wasn't properly declared that there was a commercial association because hashtag working with Samsung for Nadia Fairfax was not good enough in that case. Understand that if you do not comply with the Code of Ethics 2.7, you do not follow, say, the guidance of AIMCO, and if you breach 2.7, you very likely breach the Australian consumer law as well. It's a different law. Whereas this one that was dismissed, we have Tash Sefton. She was a very well-known brand ambassador for Volvo. So hashtag Volvo partner, the combination of the wording on the posts and her well-known association with Volvo was sufficient to make it distinguishable. But that was under 2.7. And the point I really want to make to you is that just because you comply with 2.7 and self-regulation under the Advertiser Code of Ethics does not mean you comply with the Australian consumer law. You must look at those separately and comply with those regimes independently. And there has been a case where someone in the TV realm got CAD approval for a television ad. CAD gave it a CAD approval number. It went to air, and the ACCC sued for misleading advertising. The defence was, but we got a CAD number. ACCC said, sorry, we don't care about CAD numbers. So that's the point I'd like to make there. So ladies and gentlemen, today we have traversed a lot of territory. I'm sorry, I've gone a little bit over time. I do get carried away with these things. We did a highlights tour. We've looked at copyright, privacy data, Australian consumer law, spam, trademarks, the evolving area of defamation in this space. And of course, we tied it all up with the laws, law and influences, which is a big mix of all the laws and codes as that applies. I thank you very much for your time. On our website there, you can just simply download a copy of the slides at our Knowledge Centre. Just click download and you'll get a copy of it. You don't have to sign up or do anything silly like that. Please get a copy of these slides.